The U.S. Gov Wartime Admiralty, Maritime, Military Flag. By our allowing to let these military flags fly, the American people have admitted our defeat and loss of status. Read on, you'll see what I mean. Remember, the Constitution recognizes 3 forms of law. Being governed by the law of the flag is Admiralty Law. I will cover this in a minute. The following is a definition of the legal term law of the flag. Law of the flag. The agency of the master is devolved upon him by the law of the flag. The same law that confers his authority ascertains its limits, and the flag at the masthead is notice to all the world of the extent of such power to bind the owners or freighters by his act. The foreigner who deals with this agent has notice of that law, and if he be bound by it, there is not injustice. His notice is the national flag which is hoisted on every sea and under which the master sails into every port, and every circumstance that connects him with the vessel isolates that vessel in the eyes of the world, and demonstrates his relation to the owners and freighters as their agent for a specific purpose and with power well defined under the National Maritime Law. Bouvier's Law Dictionary, 1914. Don't be thrown by the fact they are talking about the sea, and that it doesn't apply to land. I will prove to you that Admiralty Law has come on land. Next, a court case. Pursuant to the law of the flag, a military flag does result in jurisdictional implication when flown. The plaintiff cites the following. Under what is called international law, the law of the flag, a shipowner who sends his vessel into a foreign port gives notice by his flag to all who enter into contracts with the shipmaster that he intends the law of the flag to regulate those contracts with the shipmaster, that he either submit to its operation or not contract with him or his agent at all. Rustrad v. People, 57 NE 41, 45, 185 ILL. 133, 49 LRA 181, 76 AM. When you walk into a court and see this flag, you are put on notice that you are in an admiralty court and that the king is in control. Also, if there is a king, the people are no longer sovereign. You're probably saying, this is the most incredible thing I have ever heard. You have read the proof. It will stand up in court. But wait, there is more. You probably would say, how could this happen? Here's how. Admiralty law is for the sea. Maritime law governs contracts between parties that trade over the sea. Well, that's what our forefathers intended. However, in 1845 Congress passed an act saying Admiralty law could come on land. The bill may be traced in Cong Globe, 28th Cong, 2d. Session 43, 320, 328, 337, 345, 1844-45. No opposition to the act is reported. Congress held a committee on this subject in 1850, and they said, the committee also alluded to the great force of the great constitutional question as to the power of Congress to extend maritime jurisdiction beyond the ground occupied by it at the adoption of the Constitution, Ibid. H.R. Republic No. 72 31st Cong, 1st Session 2, 1850.